Good evening, students. Good evening, everyone. Any volunteer, please confirm about the voice and the video, and I'll start the session. Yes, any volunteer, please confirm about the voice and the video, and I'll start the session, students. I hope I'm audible and visible as well. Okay. So, first of all, I welcome each one of you to my YouTube session on Code of Criminal Procedure. So let's start with my brief introduction, students. My name is Sandeep Khatri. I have done my law from University of Mumbai and my LLM from Jindal Global Law School. By profession, I'm a teacher. I'm teaching law for more than 5 years now. My areas of specializations, as you can see on the screen as well, the constitution law, criminal law, commercial law, family law, and law of torts. This is the link of my profile on Unacademy, students. Please do follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me and ask questions related to your judicial preparation. And at last, I have mentioned my code, that is KHATRILIVE, which you can use to get free access of all the special classes available on Unacademy app, and also to get 10% discount for all the plus courses. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. Today I am going to take all your questions, all your queries related to the Code of Criminal Procedure, anything which you are not clear with, anything you want to ask about CRPC, any concept which is not clear to you, this is your time to ask questions. So yes, anything which you are not clear with, yes please. Yes, anyone wants to ask anything related to CRPC, and I'll explain that concept. Anything which you are not clear about the concept of arrest, or cognizable offenses or bailable offenses, non-bailable, or whatsoever, whatever you feel difficult when it comes to the Code of Criminal Procedure. Yes, students, any questions? Okay. So let's start with section number 30, students. This is one of the question which I got, usually from most of my students. Section number 30 of CRPC. So I'm explaining the concept, students. When it comes to section number 30 of CRPC, this basically deals with a situation where, suppose, what is going to be the sentence of imprisonment? What is going to be the sentence of imprisonment in default of fine? So let's understand this whole situation with the help of a simple example. Let's take an example, students. If Mr. A has committed any offense, and the offense of the punishment of that offense is, suppose, imprisonment of either description, which may extend to 3 years, or fine, or both. This is or 3 years, or fine, or both. Now, suppose here judicial magistrate first class give him the punishment of 1 year and 5,000 rupees of fine. In that circumstances, if that person, the convicted person, if he is not going to pay 5,000 rupees of fine, then in that case, in default of fine, if a person is not paying that fine, so that is default of fine. So how much imprisonment is going to be there for this default, that rupees 5,000 has not been paid? So sentence of imprisonment in case of default of fine. There comes the role of section number 30. Very good evening, Mosmi. Very good evening, Amit. I'm just taking random questions from the Cr.PC. Okay, so if you want to ask anything, you can write it down in the comments and I'll explain. Okay, so first I'm completing section number 30 and after that I will take all your questions. Okay, very good evening, everyone, those of you who have just joined. Now, continuing with this, students, in that case, there comes the role of section number 30. So the thing is, the Court of Judicial Magistrate may award imprisonment. Now, what are the conditions that has been attached to this one? The condition is, students, that it must not be more than 1/4. The imprisonment cannot be more than 1/4. 1/4 of what? 1/4 of this 3 years, which is the maximum punishment for that offense mentioned in IPC. So 1/4, the maximum of 3 years, that can be the maximum imprisonment which may be awarded for in the case of default of fine. You can also read section number 65 of IPC with this one. So that was your section number 30. Anything which is not clear to you related to this section? Okay, let's read this section once. The court of a magistrate may award such term of imprisonment in default of payment of fine as is authorized by law, provided that the term is not in the excess of powers of magistrate under section 29. Section 29 deals with the powers of magistrate. What is the power of chief judicial magistrate? What is the power of judicial magistrate first class? What is the power of judicial magistrate second class in respect of awarding fine and to give imprisonment? Shall not, now this is that point, that 1/4, shall not, where imprisonment has been awarded as part of the substantive sentence, exceed 1/4 of the term of imprisonment which the magistrate is competent to inflict as punishment for the offense otherwise than as imprisonment in default of payment of the fine. Which means it can be, not more than 1/4 of the 3 years, which is basically your 9 months. Okay. One last more point, students. The last clause of section 30. The imprisonment awarded under this section may be in addition to the substantive sentence of imprisonment for a maximum term awardable by the magistrate under section 29. So let's just take one simple example for this one. If suppose the judicial magistrate gave punishment of 3 years here and 9 months here. So this is the total punishment is 3 years, 9 months, which is in the exceed of section 29. So that is also possible. So that was your section number 30. Yes, anything else, students? I hope everyone is clear with this one. Any questions from section number 30? Okay, then let's continue this with 31. So students, the next concept here is question from section number 31. Section number 31 says, if there is a person, Mr. A, and he has committed several offenses in the sense, for example, he entered into someone's house without his permission and with the criminal intention, that is something which is criminal trespass. So he has committed criminal trespass, plus after that this person Mr. A has committed assault as well, and after assault he has committed the offense of grievous hurt. Now in this situation, as per to section 31, he has committed several offenses, and now these all several offenses, there is going to be one trial for that, and at the conclusion of that one trial, if that person Mr. A got convicted. Now the question is whether the punishment is going to be consecutive or concurrent. Now what do we mean by these terms? Consecutive here means, the addition of all those punishment. For example, the court awarded 1 year for this, 1.5 years for this, and 3 years for grievous hurt. So consecutive means in addition to all. In addition, in the sense, first he will spend 1 year in jail for criminal trespass, then 1.5 for assault, then 3 years for grievous hurt. So basically he will stay in jail for 5.5 years. Now what do we mean by this term concurrent? Concurrent here means that his all punishments will run simultaneously. Simultaneously in the sense, 1 year for this criminal trespass, 1.5 years for this assault, and for 3 years for grievous hurt, which means basically he will be out of the jail after 3 years down the line. So the answer of this question is section 31 clause 1 says that the punishment is going to be consecutive unless and until. So the general rule here is the punishment is going to be consecutive unless and until it has been specifically written in the judgment. So this is again the discretion of the judge. So if there is specifically written, then the concurrent will play its role. So this is your section 31 clause 1. Any questions from this one? After that I will continue with the clause 2 and the clause 3. Okay, I'm moving on to the clause 2. When you say section 31 clause 2, it deals with, students, in my previous example, the maximum punishment that was given was, okay, let's continue with that example only. 1 year plus 1.5 plus 3 years. That was the punishment that has been awarded. Now in that scenario, the maximum punishment was 3 years. So 3 years is something which judicial magistrate first class can be awarded. But if you get total of all these, this becomes 5.5 years. So the question is whether judicial magistrate first class can award this, whether it is not violation of section 29. The answer is no, it is not. I'm reading the exact lines of section 31 clause 2 to confirm that. In the case of consecutive sentences, so this is a case of consecutive sentences, it shall not be necessary for the court by reason only of the aggregate punishment for the several offences being in excess of the punishment which it is competent to inflict on conviction of a single offence, to send the offender for trial before a higher court. Now this doesn't mean that judicial magistrate first class will transfer this case to chief judicial magistrate. No, the judicial magistrate first class can easily award this punishment of 5.5 years. But there is a proviso given of section 31 clause 2. Now what is that proviso? Proviso says, in no case shall such person be sentenced to imprisonment for a longer period than 14 years, which means this whole term cannot exceed you. This 5.5 years cannot exceed 14 years. That is the maximum limit. Now, next clause, the aggregate punishment shall not exceed twice the amount of punishment which the court is competent to inflict for a single offense. Which means if a judicial magistrate can award 3 years, for him the maximum is going to be only 6 years. When it comes to CJM, that is 7 years, so the maximum is again 14 years. Okay. And when it comes to your judicial magistrate second class, that is 1 year, so the maximum is twice is 2 years. Now the last clause, for the purpose of appeal by a convicted person, the aggregate of the consecutive sentences passed against him under this section shall be deemed to be a single sentence. Which means, when the convicted person who has been convicted for this sentence, that person, when he will go for appeal, this all three will be treated as one only. So that is basically your concept of section number 31 and section number 30 of CRPC. Now, anything you are not clear with these sections? It's okay, Mosmi. Yes, students, anything which you are still not clear with from section number 30 and 31 of CRPC. Students, if it's all clear, please quickly give me a thumbs up. I'll come to the next topic. Okay, thank you very much. Okay, I'm moving to the next question then. When it comes to the power of arrest, who can arrest? The police officer. The police officer can arrest, but when? With warrant, and when? Without warrant. And there comes the role of the concepts of, if when we say, okay, who can arrest? The police officer can arrest with warrant. When it is a case of non-cognizable offenses. When it comes to the case of non-cognizable offenses, the police officer can only arrest with warrant only, and without warrant in case of cognizable offenses. Now these both the terms, cognizable and non-cognizable term, both cognizable and non-cognizable offenses has been defined in section number 2, which leads you to schedule 1 of the CRPC, that is classification of offenses, and one of the classification out of total 6, that is cognizable or non-cognizable. If the offense that has been committed, it is of cognizable nature, then obviously the police officer can arrest without warrant, and here with warrant. In without warrant there is one exception as well, that is of section number 42. If it is a case of section number 42, even in that case police officer has power to arrest without warrant. Let's take an example. If police officer is asking for the name or the person, the place where he belongs from, and the person is not answering, whether if first he is not answering, or even if he is answering, that is completely wrong. So on that basis the police officer can arrest without warrant as well. So section 42, and in the cognizable cases the police officer has power to arrest without warrant as well. Students, I hope no one is facing any buffering issues from my end. Please confirm that. Yes, students, please confirm whether you are facing any buffering issues from my end. Okay. Now continuing with this topic. Now who else can arrest? There is private person as well who can arrest. Then there are magistrates who may arrest. So these are your answers. Very good evening, Sapna and everyone. Those of you who have just joined. Okay, maybe there are issues of internet from my end as well because I am getting those messages. Okay. Yes, students. Anything else you want to ask related to any section or any issue? Yes, students. Any other questions from CRPC? The next subject I have already announced. The next subject we are going to pick is the Indian Contract Act. Okay, section 190. See, section 190 is about answering a question that who can take cognizance. And the answer is judicial magistrate first class. First thing first, which you have to, remember, that is the important point to remember, who can take cognizance. And the answer is judicial magistrate first class. First point. Now the second point, the judicial magistrate will take cognizance on what? Now, what do we mean by this term cognizance? Cognizance here means to taking judicial notice. So he will take judicial notice on what? So he will take judicial notice on either the police report that has been submitted under section 173 or on a complaint. He may take a cognizance, that is from section 200 till 203 then, or any information or suo motu. Okay, so these are the three situations where the magistrate can take cognizance of information or suo motu. Now, in this situation, students, if there is an FIR has been lodged, so cognizance is basically your first step to the inquiry. Okay, so inquiry begins from the cognizance. The role of magistrate. The moment the magistrate got to know about the offense, how will he get to know about that a particular offense has taken place? Either from the police report or from the complaint or from the information or by suo motu, and he can take cognizance from all these options. Okay. Now, who else can take cognizance? I'm opening section 190 now so that I can read the language and cognizance of offenses by magistrates. Subject to the provisions of this chapter. Subject to the provisions of this chapter. Why this term has been written? Because of section number 193, read with 199. Because there are cases where even other courts have also power to take cognizance. For example, under section 199, Court of Session has also the power to take the cognizance. But you can say those are some special circumstances. In general, this section only apply, and that is the power lies in judicial magistrate first class. any magistrate of first class, which is your judicial magistrate first class, JMFC, and any magistrate of second class, but there is a condition only when judicial magistrate second class may take the cognizance. Judicial magistrate second class only when he is empowered by chief judicial magistrate. So only when he is empowered by chief judicial magistrate, then only judicial magistrate second class can also take the cognizance. Specially empowered in this behalf under subsection 2 may take cognizance of any offense. Okay. And one more thing, students, one important question from section 190. Cognizance is for the offense, not for the offender. I am repeating myself. Cognizance is for the offense and not for the offender. Now, what does this mean? It means that the magistrate is taking cognizance for the matter that offense has taken place. Now, who has committed the offense? That is never the question as far as section 190 is concerned, as far as the concept of cognizance is concerned. Continuing with this, upon receiving a complaint of facts, so this is basically your 200 to 203. The complaint, this term has been defined under section 2D. So upon receiving a complaint of facts which constitute such offense. One more thing, what kind of offense we are talking about here? Cognizable or non-cognizable? So as far as your complaint is concerned, it can be cognizable as well, it may be non-cognizable as well. B, upon a police report of such fact. Police report is something which under section 173, the investigation officer will submit. You see, this is the charge sheet or this is a closure one. Next, upon information received from any person. Upon information received from any person. Okay, you can read this clause with section 125 of Indian Evidence Act as well, which means later on if this question arises in the court of law, that how did the magistrate got to know about this or the police officer got to know about this. So 125 is of Indian Evidence Act deals with your privileged communication, which means they are not bound to disclose the name of that person. Why they are not able to, why they are not allowed to? The answer is very simple, because if his name got out, then the main criminal may, kill that person as well. And this will give a wrong message to the society. And after that, no one will come out and give such kind of information to the concerned magistrate or the police officer. Continuing. Any person other than a police officer or upon his own knowledge that such offense has been committed. Clause 2. The Chief Judicial Magistrate may empower any magistrate of second class to take cognizance under subsection 1 of such offences as are within his competence to inquire into or try. So that was your 190. I hope it's clear, Amit. Sapna, please do come up with a specific question. You are asking about difference between the summary process. So I hope you are asking about summary trial. Okay, 260 and NI Act. NI Act what? You want to compare this with what? Yes, students, anything which you want to ask? Sapna, NI Act में there is no role of summary trial. Summary trial is basically for your petty offenses. Okay. Summary trial of NI Act. Sapna, I don't think summary trial concept is applicable to NI cases. If there is any specific provision on this, please mention that. Konika Sharma, you are asking, sir, police report mein final report bhi. See, Konika, police report basically is your report of investigation. Whatever investigation has been done, that is the conclusion of that investigation. And in police report, there can be two cases. First one, charge sheet, when the police officer, the investigation officer thinks that he has sufficient amount of evidences and he can easily go and prove in the court of law. Then he will file a charge sheet with all the charges and the reasons and all the evidences. So that is your basically charge sheet. And after the investigation, if the police officer feels that there are no such evidences against the accused, then he will file a closure report. So this is basically kind of, you can say, a final report, but not the final report, because there are some exceptional cases where even filing of after filing of police report, if the police officer feels like, he can continue with the investigation to collect more and more evidences, till the trial is going on. Okay, so I hope I have answered your question, Kanika. Sapna, in that case, I have not gone through in detail with the NI Act. Okay, so, but again, I'm 99.9% sure. I don't think that summary trial applies on NI cases. Okay. Kanika, police report and final report is the same thing. Okay. Yes, yes. Kanika Sharma, answer to your question, yes. Okay. (209). See, once the magistrate has taken the cognizance on police report, and after that he feels like, now they see, Amit, answer to your question, please do relate it with this one. When the judicial magistrate first class has taken the cognizance as per to section 190, either on the police report or any other complaint or information or suo motu, and finally he finds out, okay, this is the case of murder. Now what the judicial magistrate first class will do, who can try the case of murder? So the answer is court of session. So under section 209, the commitment will take place. Commitment means transfer of case from judicial magistrate first class to court of session. Now what all documents are going to be attached with that? So all the important all the information that has been written in 209. Okay. (225) is basically a trial to be conducted by public prosecutor. In every trial before a court of session, the prosecution shall be conducted by a public prosecutor. Now, once that the committal has taken place, now the public prosecutor, the role of public prosecutor will come into the picture. And when it comes to the presenting the state, who is going to present the state? The public prosecutor. Okay. Any other private advocate may help him, okay, may advise him, but it is going to be the final decision of the public prosecutor that how he wants to prosecute the case. Done, Amit? Okay, I guess I have answered everyone. So let's conclude this class now. So students, this is the link of my profile on Unacademy. This is my Telegram channel and this is my code KHATRILIVE. This is the schedule of my classes as of now. So let's crack PCS J with Unacademy, compete with thousands of aspirants and stand out from the crowd. There's a special prize week going on, students, and today is the last day from 9th December to 15th December. You can save 15% and plus 10% as well off by using the referral code. And once you're a subscriber, you can attend all these classes. This is the new thing that Unacademy has come up with. Judiciary Iconic now is live. In this, you will feel a live doubt solving, one-on-one live mentorship, main focused test series, and all the benefits of Plus as well. For when it comes to free special classes every day, you will see all the subjects are available. All these subjects are available on Unacademy, whether it is your major subjects, minor subjects, family law, your procedural laws, local laws, current affairs, all the classes are available. These are some important special class features: interactive live classes, poll for learners. You can raise your hand and you can actually communicate with the educator. You will get the notification, so you will not miss any of the classes. You will get the lecture notes and you can access them anytime, anywhere. India's best educators are available for you. This is the pricing plan in general students, which is not applicable for today also. And you can always use this code KHATRILIVE to get 10% off. This is the YouTube and the Telegram channel of Unacademy. And on that note, thank you very much. Like, share, and subscribe. And yes, it's time to say peace.